Hello everyone, welcome to IAS Baba's rapid revision series or the 60-day plan. So here again we are going with the day 2 and polity again. So here we are discussing the fundamental rights and the day 2 principles. So before going through the topic, so spend some thought process on how UPSC asks a question. So if you see the previous questions, so it is like which of the following will enable welfare state, or what is the justiciability, what is the enforceability. So such terms are more often coming, and you are not getting questions on which fundamental right belongs to which article or which directive principles belong to which article. So all those things questions are not coming. So having such thought process, we will approach this chapter also. Okay, so we begin. So here are the list of topics we are going to discuss, and these are already provided to you prior. Okay, so we will start with the first one, the current status of fundamental rights with respect to DPSPs. So for us, what is the current status is more required. So before moving to the current statements, we will have a brief history. Of course, these are not that important for prelims perspective, but for the derivation of that, these are required. So Champakam Dorarajan case, so it said that directive principles so must be subordinate to fundamental rights. Okay, so this was against the Shankari Prasad judgment, and then the parliament replied with Article 46, okay, the first amendment of the constitution, and then Golaknath case came. In the Golaknath case, Supreme Court again said fundamental rights cannot be restricted or reduced to execute a directive principle. Then the government replied with the 24th amendment, okay, so that altered the Article 13 and Article 368. So we know that the amendment clause was amended saying that the procedure of the parliament to amend and the power, so both were included. So the clause read like this: the power to amend the constitution and the procedure thereof. Okay, so such hiccups between the Supreme Court and Parliament was going on, and here the Keshavandra Bharati case. So we know that the Supreme Court said we can amend even the fundamental rights but not the basic structure. Then Parliament came up with the 42nd amendment. So in this 42nd amendment, the Article 31C was introduced. So in this Article 31C, it said that any article, so any article which are amended in the directive principles, so they cannot be called into question if they violate the Article 14 and 19. So like after 42nd amendment, we got to know that all directive principles, so they take precedence over these two articles of fundamental rights, that is 14 and 19. Okay, so then in the Minerva Mills case, Supreme Court struck down that clause, and it said that only the amendments to Article 39B and 39C, so these can violate Article 14 and 19, so others cannot. So now if you take fundamental rights and directive principles, okay, so here only two directive principles, so that which come in 39B and 39C, so they stand above only two fundamental rights, that is 14 and 19, okay, and nothing else. Okay, so here not the whole globe is above, only that a part of DPSP, that is 39B and 39C, is above the 14 and 19th article. So this is the status. Okay, so you can take a figure of this and you can remember likewise. Then coming to second one, fundamental rights, constitutional rights and legal rights. So here again there was a question and many of you had committed a mistake. So what is a fundamental right, how it is with respect to the constitutional right, and how it is a legal right. Say for example, if it is a fundamental right, so but obvious if it is present in the part 3 of the constitution, so that happens to be a fundamental right. So now even if it is a fundamental right, so it is also a legal right, okay, and it is also a constitutional right also, because fundamental rights are the most stringent ones. So if they are in the part 3 of the constitution, so but obvious they are present in the constitution also, and they are legal also. No fundamental right can be illegal. So make sure that you remember these things. So such small thought errors, so you will commit in the exam. Say for example, Article 17, so right against untouchability. So this is a fundamental right. This happens to be a legal right when the parliament enacts SC/ST Atrocities Act. So this act was enacted to give force to the fundamental right. So, but obvious fundamental rights, they give only the thought points and the details have to come with the help of law. So, laws will always be supplement to this. If fundamental right itself, if it cannot enforce anything, so then there will be laws which give in detail enforcement objectives for them. So, you take any one, say for example, we have Article 21A. So, Article 21A is a fundamental right. So, here we have various laws, rules and regulations, RTE Act is there, Sarva Shiksha Abhiyan rules, new education policies. So, all these, they are supplements to the fundamental rights. So, a fundamental right happens to be a constitutional right, it happens to be a legal right as well. So, then coming to a constitutional right. So, a constitutional right will not be a fundamental right. Okay, right to property is a constitutional right. It is not a fundamental right anymore, but it is also a legal right. Okay. There are various laws on property acquisition, property ownership, etc. So, the whole contract laws in your law subject. So, all these deals with the property rights. So, but obvious it happens to be a legal right because there are many laws which supplement this constitutional right and legal right, but obvious they are the legal rights. So, remember this picture, fundamental rights are the core ones and they happen to be both, and constitutional rights, so they happen to be legal also, and legal rights are always legal. So, these you have to remember. Then absolute and non-absolute fundamental rights. So, how will you deal with this? See, for example, here there are various restrictions provided in the constitution, there are various restrictions provided in the law for various fundamental rights. Okay. So, majority of the fundamental rights, they come with their own restrictions. So, we know that right to privacy is not an absolute right. So, there are reasonable restrictions. Right to freedom of expression is not an absolute right. It comes with the reasonable restrictions. But there are some fundamental rights which happen to be absolute. So, there it is very insane to think about the reasonable restriction for them. Okay. Say for example, right to untouchability. So, there is no reason for you to give any exception for some person to go and practice untouchability. Okay. So, it is banned at any cost. So, at any cost, society has to eradicate that. There is no other option. Okay. And then right against paying tax to a particular religion. So, you cannot say that any exemption should be given and tax should be paid for any particular religion. Okay. So, here tax is not fees, etc. So, tax means the tax itself. Then the right to education. So, you cannot say that from 6 to 14 years of age, so someone should be deprived. So, there is no such exception for these. Okay. So, these happens to be absolute rights, but however, all these rights which are above, so they come with their own. So, Article 15 gives exemption to women in case of arrest, prison, imprisonment and others. Okay. And then Article 16, so that gives so many exemptions. So, 4, 4A, 5, so all these are exemptions only. And then the Article 18, so that gives academic and positional titles as an exceptions. So, I can have MBBS or I can have BTech degrees as my suffix in my name, or the personal titles. So, positional titles like Lieutenant Colonel, Lieutenant General, so all these, so they happen to be an exception to Article 18. So, Article 19, the public health, the morality, decency, so all these. So, remember there are two kinds of right, absolute and the non-absolute rights. Okay. So, if any law, if any constitution mentions those exceptions, so they happen to be non-absolute, else they happen to be absolute ones. So, remember this. So, UPSC didn't ask any question regarding this, but this is also one of thought processes. So, so many institutes, they have been asking this in a mock tests. So, I brought this here. Then, fundamental rights specific to citizens and otherwise. Okay. So, here whenever it comes for the fundamental rights, so we have a clear detail that these and these are the rights which are specific for citizens. So, Article 15, 16, 19, 29, 30. So, remember these numbers 15, 16, 19, 29, 30. But here what makes it a different? The very word the citizens are present in the constitution itself. Okay. The state shall not discriminate the citizen of India. The state shall not deprive a citizen of India. So, that word citizen is present within the article. So, that is why these are specific to the citizens. Okay. So, now the question is, if there is any constitutional right, okay, so whether those constitutional rights are they restricted to citizens or are they open to all? So in this case, what we are going to do? So here also both are there. So there are fundamental rights which are restricted only for the citizens, and there are fundamental rights which are open to all. So apart from 15, 16, 19, 29, 30, all others are the fundamental rights open to all. Here also there are constitutional rights only for citizens. So adult franchise. So the right to vote is only for the citizens, but however right to property is open to all. So this right to property so doesn't come with the word citizen. So we have to have knowledge on what is the wording of the article to hit such questions. So make sure that along with any other basic book you read the raw constitution. Okay, so what the constitution actually provides in its clause. So if you have that idea, you will get to know. Say for example, if there is any body, okay, so which is set up on a peripheral basis, so that will not be a constitutional body unless and until there is one dedicated article for the body in the constitution. Say for example, CAG has a particular article, so it happens to be a constitutional body. Or finance commission, there is a dedicated article. UPSC, there is a dedicated article. So make a habit of reading the constitution and its clauses verbatim. Then education. So here we have some of the fundamental rights, Day-2 principles and fundamental duties. So these are all of them. So you can always get a question like the education. So it is what in the constitution. So it is a fundamental right, it is a Day-2 principle, and it is a fundamental duty. So all the three are present. Okay. So here we have Article 21A. So state shall provide free and compulsory education from the age of 6 to 14 years. Then Article 45, 46 and 41. So all these they carry education. So provide early childhood care and education for all children until they complete the age of 14 years. Okay. And promote education and economic interest of SC/STs, and also we have to make sure that they are uplifted from social injustice. Then Article 41, so right to work, right to education. So again it came, and then fundamental duties we know, provide opportunities for education to his child or ward between the age of 6 to 14. So every parent has a fundamental duty to educate a child or ward from 6 to 14. So here in the fundamental right, the word 6 to 14 is mentioned. In the fundamental duty, 6 to 14 is mentioned. In Day-2 principle, nothing 6 is mentioned, only the 14 is mentioned. So make sure that, so such differences you will learn here. So UPSC exam is critical observation, not by heart. Then DPSP and welfare state. So there was an open question like which of the following will explain the welfare state. So apart from that, we have to make sure that what are the welfare states DPSP will provide. So we need not by heart, we will just mark the keywords which depict the welfare state, and then we will remember. So here Article 38, so it provides for justice, social, economic and political. So such words will come verbatim in the exam. So make sure that you will concentrate on that. And then livelihood for all citizens, equitable distribution of material resources, prevention of concentration of wealth, then equal pay for equal work, and health and strategic strength of workers, and then opportunities for healthy development. So equal justice and free legal aid. So all these. So these come under the social liberal principles, because here the government is going and doing for the people, for the weaker sections. So wherever weaker sections come, so though they come under these socialistic principles. Then what will be Gandhian principles? So they will be under Gandhian ideology. So not to smoke or not to drink, or might be Gram Swaraj, okay, cooperative societies, okay. So non-violence, truth, ahimsa, Gram Sabha. So on these ideals you think, and you will get all the Gandhian classes. So which are not there in social, which are not there in Gandhian. So they come under the liberal ones. Okay. So likewise with the concepts you have to hit. So you cannot by heart each and everything here. So I have brought in the social one, the Gandhian and liberal we take in any other class. So we go with the piecemeal approach. We won't flood our brains. Okay. So here we have in case of unemployment, old age, sickness, disablement. So the right to education we have to give. We have discussed this. Then make provisions for just and human conditions of work and maternity relief. So your Maternity Benefits Act and your the labor codes. So all these come under here. So as this is in news, current affairs, so labor codes, So we will make sure that we will stress on this. And moreover, the labor codes question was already there, that all casual workers are entitled for provident fund. So all those statements in that 2021 prelims question, so that is present in the labor codes. So it has already come. We will see whether it repeats or not. Then securing a living wage. Okay, so here mark this word living age, a decent standard of living. Okay, and other opportunities, cultural opportunities. Then 43A, steps to secure the participation of workers in management of industries, and then raise the level of nutrition and standard of living. Okay, so all these are the social principles. So we will make sure that we will mark the keywords, and whichever are in use, so we will remember them. Okay, then come to next. So enforceability and justiciability of DPSPs. So here we have two words, that is justiciable and enforceable. Okay, so here it is like justiciable means enforceable by courts. Okay, so these DPSPs are non-enforceable by courts of law, or they are non-justiciable in nature. So that means that we cannot approach the court in the name of violation of DPSPs. Say for example, if someone is not given the fair wages, or if he is not given the living wages, okay, so we cannot go to the Supreme Court and ask that I am not being given the living wages. Okay, so it is left on the employer unless and until he violates the human rights, so he can give any payment for that matter. So likewise, these are not justiciable, or they are not enforceable by courts of law, but they are enforceable by parliamentary law. So remember these two words, they are, DPSPs are not enforceable by courts of law, they are enforceable by parliament's law. So parliament can enforce it. Parliament with various rules, they have enforced the labor codes, they have come up with the Sarva Shiksha Abhiyan, they have come up with the geriatric cares, the geriatric care centers, so old age care centers. So all these have been taken up, they are enforced by law. So make sure that you will remember these things. The DPSPs are not enforceable in the courts of law, but DPSPs are enforceable by parliamentary law, or just they are enforceable by law, but they are not enforceable by courts of law. Okay, so remember that. Okay, and here we have this question. So here it is like enforceable by any courts. So this was the question asked by UPSC. So enforceable by courts of law. So this happens to be, okay, correct statement, because they are not enforceable by courts. So here the both 1 and 2 will be the answer. So they are not enforceable by courts. Then writ petitions and principles of locus standi. So here also we need not by heart which writ petition comes with the locus standi, which will not come. Okay, so here it is like the habeas corpus. So habeas corpus will not have any locus standi. So what is a locus standi? It is like apart from the aggrieved person. So can any other person, so can he apply the writ petition on his name? So if we take the public interest litigation, so that is the very dilutest principle of locus standi. So even if I am not at all a kith and kin of anybody, even if I am concerned, so I can go and apply the petitions. So it is like locus standi is one wherein only the aggrieved person, so he will approach the courts of law. Okay, so if any non-aggrieved person, or if a person is not related to an aggrieved person, if he approaches court, so that petition will not hold true. So here the locus standi is diluted for habeas corpus, because habeas corpus, we know it is that if someone has detained a person, so court orders them to release. So if a person is detained, and if a person is immobile, and if a person is incommunicado, that means he has gone out of communication. How he will come to the court and approach? So hence any other kith and kin can go and apply the writ petition. So that is why there is no locus standi here. And also for quo warranto, there is no locus standi. So quo warranto is like if a person is acting against his jurisdiction, or if a person doesn't have authority to act, but even still is acting. For example, I am not cleared IAS, but I am acting as IAS officer. So any person in the public, they have that right to question at what authority you are working here. So that is the social justice. Hence, the locus standi applies for quo warranto. So only for these two. Others, for mandamus or certiorari prohibition, locus standi is present. So when we discuss this locus standi, so there is a hidden concept behind this. So hidden concepts, wherever they are, UPSC has a question. So along with that, we discuss the natures of these. So whom it can give and whom the court can't give these writ petitions. So habeas corpus, public officials as well as private persons can be given the writ petitions, because even if a private person abducts you and if he keeps you in some place, so court can order to release immediately. Mandamus, so public authority, judicial bodies, quasi-public authority to perform legal duty. So here this comes with the tag legal duty. So whenever the duty is legal, only then you can give a writ petition of mandamus. So you cannot say a private person to do a legal duty. So this is not the legal duty of a public who has abducted you to release. Okay. So it is a non-legal duty. So a legal duty comes only for government and only for government officers. Mandamus is given. Then certiorari, so inferior courts and tribunals. So this is but obvious. So if a court has decided against its jurisdiction, so but obvious, then prohibition. If a court is deciding against its jurisdiction, so these two are specific only to the quasi-judicial and judicial bodies, and here prohibition can also be given to administrative authorities. So here mark this one. Okay. So certiorari only for courts and tribunals. So administrative authorities cannot be given with certioraries. Then quo warranto. So here substantive public authority only. Okay. So quo warranto means I am a public official. That is why I am acting on my duty. Okay. So but obvious this happens to be given to public official. So if you give it to non-public official, he happens to be a fraud, and but obvious he is amenable for the punishment. So these are the writ petitions. Then the personal data protection bill. So this also is in use. So we discuss in brief what all it says. The bill governs the processing of personal data by government, companies incorporated in India and foreign companies working with Indian data. So mark these three. Then obligations of data fiduciary. So data fiduciary means the person who operates the data. So personal data can be processed only for specific, clear and lawful purpose. So they should inculcate some safeguards, security safeguards, such as data encryption and prevention of misuse of data, all those things. Okay, and they should have a grievance redressal mechanism. So they should be having a helpline, a complaint number, so that I can complain and get my grievance redressed. Then rights of individual. So seek correction of inaccurate, incomplete or out of date data. So if someone is publishing an incorrect data on me, so I can call them and say that no, publish a correct data of mine. So this is a morphed video of mine or a morphed picture of mine. So don't do that. So such things are presented in this, the data protection bill. So moving further, the grounds of processing personal data only if consent is provided by individual. So if a person is giving consent, only then you can process the data. But however, even without consent you can do, but only in certain circumstances. That is, the state is giving a benefit to an individual. Say for example, Aadhaar card. Yes, and then legal proceedings are going on. So we can use the data. And then medical emergency is there. Then we can use the data. Then exemptions in the interest of the security of the state, public order, sovereignty, etc. Even then, so we can use the data without the prior permission. Then offenses. So if anybody is violating all these rights, so he will be punishable under any law, and even under this law, the required penalization and imprisonment will be given up. Then new IT rules and liability. Say for example, during the farm bills, so this IT rules was formed, and this also contains some of the crucial clauses. So we will discuss this. In case of due diligence is not followed by the intermediary, the safe harbor provision will not apply to them. So here, what is a safe harbor provision? So say for example, government is coming up with IT rules, and if a person is not following these IT rules, and if they are not following the due diligence, and so many controversial messages are coming up from my social media company, so but obvious I will lose my safe harbor clause. So safe harbor provision is given only to those media which are in the good books of the government. So they are good boys as per the government. So they won't do mistakes, and for them some concessions will be given in case of inspections, in case of punishments and others. So if you violate that, if you don't follow due diligence, you will come out of the safe harbor provision and you will be in the unsafe harbor. So unsafe harbor means government can take action at any point on you and it will be keenly inspecting you. So you will be out of the safe harbor if you don't follow these safeguards. So in the unsafe harbor zone, so you are amenable for any kind of punishments. Okay. So and after that, so what are the things that IT rules stipulate? So intermediates shall appoint a grievance officer to deal with the complaints. Okay. So every intermediary should have the grievance officer, and this officer should acknowledge the complaint received within 24 hours and they resolve the issue within 15 days. So there has to be a coordinator, and then intermediaries should remove or disable within 24 hours. So any controversial content, and then complaints of such nature can be filled either by individuals or a person on behalf of the individual. So complaint can be filed on anyone. So there is no principle of locus standi here. And then they have to appoint a chief complaints officer, a nodal contact person, and a resident grievance officer. So and all these officers should be Indian residents. So like all these should be Indians, because if there is any wars, so they will work in favor of the government, and they should publish a monthly complaints report, so detailing the complaints received, and all intermediaries should establish the identity of the originator of the message. So who originated and who forwarded. So in WhatsApp you get the forwarded message, or if you have typed it, it comes as an original message. So such things to identify who created that message and to penalize the culprit. Okay, then an intermediary upon receiving an order by the court or being notified by the appropriate government should not post or publish any information. So once the direction is given by the government or the court, you should stop publishing any controversial informations. Okay, so these are some of the IT rules. So factual questions might come. There was a question on cyber insurance. Okay, so detailed question. So such questions we can expect. Then Pegasus and privacy. So here, so it is like we know about the Justice Puttaswamy judgment. So where it is like the privacy, right to privacy. Okay, so it is a fundamental right. Okay, although some reasonable restrictions are there, but the right to privacy is given utmost paramount whenever a state happens to snoop on the citizens. So just because right to privacy is not absolute, that doesn't give a right on the government to snoop on the people. So whenever the government itself is violating right to privacy, so that will be curbed at the very first instance. So the Pegasus judgment and the Justice Puttaswamy judgment, they said the same. So the government primarily should not be violator of privacy. And here in this Pegasus judgment, it also said that, so it is like the principles of natural justice was also violated here. So whenever the government went on to set up its own committee, so it is like it happened to be the judge for its own cause. So again in the Pegasus, so the legal perspective of Pegasus, whenever you study, you go with one thing, principle of natural justice, that is government happened to be the judge of its own cause. Then the right to privacy. Okay, so right to privacy becomes absolute if government is a culprit. Okay, so if government is violating, so then it becomes paramount. Okay, so this is Pegasus and privacy. And then justiciability of fundamental duties. So here also the same holds good, that is enforceable by courts, no. Enforceable by law, yes. Yes, fundamental duties are not enforceable by courts, or they are not justiciable in nature, that is not enforceable by courts, but we have Environment Protection Act which enforces fundamental duty, and we have Prevention of National Honors Act which punishes a person if he disrespects the national flag, national anthem, etc. So this shows that enforcement by law is correct, by courts wrong. Then come to next, Indira Sawhney case judgment. So various debates and discussions happened in this. So we have a brief on this. So backward classes under Article 16(4) cannot be identified on the basis of economic criteria but overall social, okay, socio-educational, not just the economic, okay. So here it is like many governments, including central government, they went on with the EWS section. So on that, so this Indira Sawhney came into picture, okay. So apart from this, so reservation shall not exceed 50%. So here this 50%, so this came in news because many state governments, so they were expanding the reservation for backward class. So that is why this 50% came into picture. So 65%, some 70% reservations are being announced. So especially during the election year, so that is why. And then any disputes regarding the criteria were to be raised in the Supreme Court only. So this was the Indira Sawhney judgment, and some other clauses like Supreme Court of India refused to lay down any yardstick to grant reservation in promotions. So this judgment came in 1992. So it said no reservation in promotion, and Parliament replied it with the Article 16 4A. So this 4A is small one. Okay. So it said that the reservation in the matters of promotion and consequential seniority is allowed. So Article 16 4A. So that gives for promotion. So right now promotion is there and reservation for promotion is also there. Okay. So these ones and the context why Indira Sawhney judgment came. So it is like Madhya Pradesh to increase OBC quota and implement EWS, and also the reservation of economically weaker sections. So this is all about Indira Sawhney case. Then Shatrughan Chauhan case and the right to life. So here, whenever the Nirbhaya case was prolonged and it took almost 10 years to award death penalty for the culprits. So here again, that dilatory in execution of the capital punishment convicts. So that was in news. So here the Shatrughan Chauhan case said that whenever you are delaying a death penalty, so you are commuting it automatically. So auto commuting to the life imprisonment. So who gave you permission to convert a death sentence to life imprisonment? So in this administrative failure, you are making the law a culprit centric or convict centric and not victim centric. So we know that whenever justice system is there, we have to go for victim centric judgment, okay, victim centric laws. So and this is the convict centric. So one was that idea. The second idea is that whenever you are prolonging a death sentence, so even the convict is harmed. So his mental trauma, so it is unimaginable. So it is a violation of the right to life if you prolong a death sentence. So today you are about to hang, but you will not be informed. You will prolong to next week. So in that whole 1 week, the mental trauma that person appears or experiences. So all these things. So but obvious, they will impact the convict also. So this harms both the victim as well as the convict. So we remember these two things here. And then powers and limitations of state governments with respect to reservations. So as I said, many state governments, they went for the reserving the jobs for even in the private institutions. So even in the private jobs, so there were reservations for local peoples. Okay. So Karnataka, Haryana, so many of them they gave. So here we will discuss like what is the cases all about. So here in Mukesh Kumar case versus State of Uttarakhand, the apex court, Supreme Court said that reservation for disadvantaged groups were not a fundamental rights. Okay. So Supreme Court repeatedly said this, that is reservation is not a fundamental right. So we have seen Article 16, 16.4, all these. So but why reservation is not a fundamental right whenever we have an article? So we have to look into keenly in that perspective. Say in that when we speak of the Article 16, so it firstly speaks that there should not be discrimination in employment, and then it speaks however. So whenever a state goes for reserving, so that will not be contradictory to this first clause. So all those whatever reservational clauses we have, so 16, 3, 4, 4A, etc. So these are the exceptional clauses. So they are empowering the state to give reservation, but they are not the right given to the people. Okay. So if a state gives, it is okay, but citizens though they don't have the right to demand it. Okay. So I cannot say that give me reservation, but if the state identifies and gives to me, then I can receive that. So this we can say it is an enabling clause. So embedded in the fundamental right. So this is not an inhibition clause for any state. So but obvious. So that doesn't happen to be a fundamental right. So in that context, if you take, so right to reservation is not a fundamental right. So this is the current status. So in prelims, if the question is asked, is right to reservation a fundamental right? No, it is not a fundamental right, directly said by the Supreme Court. Okay, and now if you take Haryana reservation bill, so when Haryana reservation bill, it was stayed by the Haryana High Court, Chandigarh High Court, Supreme Court vacated that stay. So it said that no, you can go ahead with the reservation. Why it was? So it was because Haryana High Court failed to give any evidence, okay, against the case. So it didn't give any evidence to prove that. So this violated the constitution. So this violated. So the fault was with the Haryana High Court. Okay. So it is not the meaning like Supreme Court gave a full-fledged green signal for this reservation in private jobs. It has only said that the High Court's duty was not optimum. If they come up with evidence, I will also uphold the stay. Okay, so here the fault is not in the reservation, it was with the High Court which didn't give any evidence while giving the stay order for the reservation. And coming to the Karnataka's bill, it went to the President. It didn't go to Supreme Court or a High Court, it went to the President, and President refused to sign the bills. Okay, so as of now, the Indira Sawhney judgment 50% rule stays. So until the judgment of Supreme Court in the EWS case or others come, so it stays, and for promotion also it stays. Okay, and at the same time, right to reservation is not a fundamental right. So with all these, we will conclude. Okay, so in the last, again friends, see, whenever we are going to achieve something, so all these hurdles, all these are a normal thing. So Adolf Hitler had once said, if you achieve something despite any difficulties, you win a victory. But if you attain something in spite of all difficulties, you create a history. Okay, so if you are having so many difficulties, make sure that that itself is a history in your life. Okay, so if you fail in many times, so and then if you win, so you will be having that thrill, and that will remain in your brain for maximum number of days. So make sure that at the time of your death, so have many such memories of successes after multiple failures. So do that and do the same with the civil service exam. Come out with flying colors. All the very best. Good luck, friends.